final matter to come before us this morning is Thomas Lavery versus City of Akron, Department of Public Service. Both sides will have 15 minutes to argue. As the appellant, you may reserve up to 5 minutes for rebuttal. If you want to reserve that time, if you let me know when we get started, I will be keeping the clock this morning and can advise you as to your rebuttal time. We've read the briefs and we are ready to proceed when you are.
I appreciate my name is Thomas Lavery, and I appreciate your time on what should be a rather simple case, but has just gotten extended and blown way out of proportion. Anyways, I would like to try to get the thing all cleared up. This issue right now seems to be a little, sort of a little technical issue, which the city has been trying to pull on me, and they've done this several times in the past on the previous part of this case. And if you've read the brief on this, you would see most of the stuff in it, but I would also ask that maybe in the process of the case that you go back to the previous part of this case and actually went clear back to June and July of 2011, where the first thing was starting. There's an awful lot of background with this beyond what the little technical thing is going on right now. I did not get to file a reply brief in this case because I was waiting for an answer or a decision from one of the appeals court, this court's cases that apparently had an argument in April. And the decision didn't actually come down until September, which put me behind on trying to get a reply brief in. So I'm going to try to do some of that now. And I'm primarily referring to a bunch of things that were in the, I'm sorry, I would like to reserve 5 minutes at the end. The city brought up a whole bunch of different cases on here, on their list, their table of authorities. Most of those don't even apply to this case, and it's a situation of like somebody can take things out of a Bible and twist things around, pick and choose little pieces of stuff to prove one thing one way or the other. And that's pretty much what they've tried to do with this. That's what they tried to do before. Anyways, these various cases on here, the one of them, they've only taken little parts of the thing out, even with my appeals case, which was decided on March 13th, 2013. And they tried to simplify that, and the one currently saying that, well, I just didn't file a brief, or there was confusion or something. No, there's a lot more behind it than just confusion. And one of the cases that they referred to was this meter one. The guy was an attorney, and he was filing stuff late. I was able to get into the background of some of these cases, and unfortunately, December 7th and 8th, there was a massive arson fire where I had all my legal records and all kinds of other things, which really doesn't concern the court, but it's like 40 years of my life went down the tubes, and I'm trying to reconstruct stuff. I got most of the things that I needed for this case as such. There was another one, a Manly case that they referred to and took a little piece out that was also the appeals 9th district, that's this court here. And they were trying to, the lady that ran that case actually got supported, held up from here. It was affirmed, I believe, I don't remember the exact language. And I'd like to note too that that case wasn't even decided until June 30th of 2014. So how could I even know what was in that case 3 or 4 months ahead of time? And that's what they're trying to bring up.
Oh, is that Matrix Acquisitions versus Manley site that they cite, that you're
Yes.
speaking about?
Yes, it is.
I just want to make sure.
There was a credit card dispute too, but anyways, she was upheld on the thing. And the decision was not until well after anything that could have been done here. Now, they are constantly pushing on the thing about, I didn't check the docket, I didn't check the docket, and so on. Well, after the thing was remanded the first time, I got nothing in the mail to find out anything, any other developments on the case, until in May of 2013, I got a note from the one judge switching it, I guess, to the other judge. I never heard anything else after that. They're trying to make, the city is a deal that, well, I should have kept on this thing and I should have been pestering the judge or whatever the term was to try to get the case going. I didn't, I just waited until I get something. Sometimes the cases take years. It's just the way things are with it. Anyways, they were making a big deal about, well, I didn't file a brief for a year or for almost a year or something like that. I didn't get any notice to do anything. They finally, as is noted in here, in February of 2014, filed a thing for briefs, and they said that I didn't check the dockets. Well, I'd like to know how he says, or how he knows I didn't check the docket, because after I got their letter, I did check the docket, and I actually had a thing printed up. It was about a week or so after that I got their notice, and I never heard anything else from them.
Are you referring to the notice of the transfer of the case? When you say after I got their letter, oh, and then you said after I got their notice, I'm just trying to understand, what document are you referring to?
From February, I think 7th or 11th or something like that of 2014, and they wanted this Judge Rollins to set up a briefing schedule, which apparently she did, but I didn't get to know about it.
You were aware at that time when you received that there was going to be a briefing schedule set though, right?
Well, I figured yes, and then I would find out when I got notice as to when I was supposed to do anything.
When you say check the docket, what does that mean in your words? What does that mean to you, check the docket?
Well, I can go to the library and punch the thing in, or I can come down here, and in that case I went to, I don't know, Kinko's or something like that, and check to see if there was anything on this, on the Judge
You looked up
Rollins
your case.
site, and there was nothing on
You
there.
looked up your case.
So as things had extended, yes,
Okay.
as things had extended, I figured, okay, when they get around to it, they'll let me know. And I didn't get anything else until much later, and that's all listed in here as far as April 8th and April 29th and so on, that the thing had been thrown out. Now, I also got a minor problem, maybe it's not minor, I don't know, as to how somebody from the city, I mean, this isn't just a civil case, one party against another one. It's a city executive department, and they're writing out the things that Judge Rollins, or maybe this Tammy O'Brien, or the clerk, or somebody in there does, which is part of the judicial department. Is there a conflict there? I don't know. Again, the merits have been totally ignored in this whole thing, and apparently they're deliberately trying to do that, and they were trying to do that before. And in a previous case, which I got sabotaged on because of some kind of technical thing that wasn't my fault, it turns out it was a clerk's fault in the common pleas court, but I got dinked on because of that. Anyways, they state about you don't have any business doing anything on the merits and stuff. But I believe I put something in there about looking from the Ohio Constitution or something else that said you do have the right to review or to overturn, or I don't remember all the words on it, but it was on the end of my brief, one of the appendix pages on there. You folks can decide this case. It doesn't have to go back again and cycle again and so on and so forth. one of these things, and it referred specifically to I'm referring to their brief on page 6, and they took a little part out of this Marshall case, which was a financial case. Again, it really didn't have anything to do with, like, the dispute with me and the city. However, there was a thing in there that says it has been held that notice shall be deemed to have been provided once the clerk has served notice of the entry and made the appropriate notation on the docket. And it's like their duty to check the docket. Okay, that's fine. I did check the docket a couple of times, and we never heard anything. But how often am I supposed to check the docket? Every few days, or every week, or something like that? I figure, as it's been the past practice through the common pleas court, and even here, that when I get some instruction to do something, I follow it. But
And you are just now reaching into that 5 minutes. You can continue or reserve as you wish.
I just have just a second more on this, and then I'll take my 5 minutes. It said, once the clerk has served notice of the entry and made the appropriate notation on the docket. So there's two things that they have to do. It has to be and. It's not just plain check the docket. Thank you.
May it please the court, my name is John York. I'm appearing on behalf of the city of Akron, the appellee in this case. In a very recent decision yesterday, in fact, in the case of Hodges versus the city of Akron, case 27246, the court reiterated its rule and the common rule in the state of Ohio that the appellate court would review the trial court's interpretation of its local rule for an abuse of discretion.
And Mr. York, it seems this is the day. We've apparently been issuing several decisions, and I realized this just came out yesterday. Usually we need a motion supplement to allow one side to make the argument that the other side is not prepared to counter because the authority has not been made a part of this record. I completely understand that it just happened yesterday.
Rather than complicate matters, Your Honor, I'd like to, if I could, withdraw my argument or reference to Hodges and just rely on the cases in my brief.
Okay.
The city contends that in this case, the court below properly applied and interpreted Local Rule 19, that it did not abuse its discretion, and that therefore the decision should be affirmed. Local Rule 20.03 does not appear in my brief. In fact, I didn't learn of Local Rule 20.03 of the Summit County Common Pleas Court until preparing for this argument. But it in fact places a 6-month limit on the handling of administrative appeals. I don't argue that that rule is carved in stone, but in this case, Mr. Lavery has had 3.5 years to file a brief. He appeared before the Housing Appeals Board in 2011. And during that hearing, he contested orders that were issued to him to make repairs, and he admitted that those repairs needed to be made. So were we ever to reach the merits, I don't know how he could possibly be successful, but that issue is not even before the court. The only issue before the court this morning is whether the dismissal by Judge Rawlins below was reasonable, considering that the court must defer to that court's decision to dismiss the case. Just as a brief history, the first time this case was up, which was decided in March of 2013, the court noted that there were ambiguities in the record that led to Mr. Lavery's confusion. One of those ambiguities was which judge was on the case. There was originally, I believe, Judge O'Brien, I'm sorry, it was Judge Rawlins originally, then transferred to Judge O'Brien. Mr. Lavery pointed out that that confused him. He didn't know where to file his brief, so he didn't file one at all. After this case was remanded for further proceeding, Judge O'Brien put an order on that said, based on the Court of Appeals findings in the opinion, it's not her case. The case is Judge Rawlins. So that issue was cleared up. We believe that Local Rule 19 itself puts Mr. Lavery on notice of what he is to be doing. It's not the court's job to put out an order that says do something. Local Rule 1903 says file a brief, and file it within 30 days of the filing of the record. The record had been filed for a long time, several years. And then 11 months after this case was remanded, when Mr. Lavery still had not filed anything, the city moved the court to set a briefing schedule. We feel that put Mr. Lavery on notice, heightened notice, that he needed to be checking the docket or in some way respond. If he felt that it wasn't appropriate to have a briefing schedule set, he could have objected or responded in some way. On February 28th, the court did put on a briefing schedule, and it clearly stated that Mr. Lavery's brief was required to be filed by March 31st of 2014. And it also warned the parties that failure to comply with the briefing schedule could result in dismissal. When Mr. Lavery did not file a brief, I think the city waited a week or two after his brief was due and then moved to dismiss. And then finally, a month after Mr. Lavery's brief was due, after he still had not responded in any way or filed a brief, the court did dismiss the appeal. We believe that case law is clear that as a party, Mr. Lavery, even as a pro se party, has an obligation to check the docket regularly. And we would argue that's even a more heightened degree of vigilance necessary, considering this case is really 3.5 years old. Even a pro se party, and it's pointed out in the case law in the city's brief, cannot blame the post office or the mistake of another for his lack of knowledge, because a party has a duty to check the docket. And I don't know, or I didn't know, is not an acceptable excuse. We would just ask that this court affirm the decision of the court below dismissing the appeal, because the court did set a briefing schedule and warned the parties of the consequences of failure to satisfy the briefing schedule. Mr. Lavery did nothing. He did not oppose the schedule. He did not seek an extension. He did not file a brief. And the court below, the city contends, reasonably applied Local Rule 19. And if there are any questions, that's all I have today. Thank you, Your Honor.
Thank you. Mr. Lavery, you have just over 4 minutes remaining for rebuttal.
Okay, thank you. What he started out with, and then I guess erased or something or other about this Hodges case, this is the kind of stuff that they've been pulling on me for a long time. And he refers to this case being 3.5 years old. It's not my problem that it got dragged out so long like that. I wait for instructions to get something from somebody, and I do it. And in the previous case, which I said I got messed up job on another house back in 2009, if you want that case reference, I can give that to you anyways. But it was a case that the clerk made a mistake on in instructions to me, but I got hung on it. And it's the same type of a thing that I'm getting stuck on these things. He says there was a notice about the briefing schedule, and if not appropriate and not warned, it was going to be dismissed and so on and so forth. I didn't know about any of that stuff. But in this other case, back in 2009, it was a Judge Unruh that had that time. She sent out a notice that says, brief due on this such and such a time, reply brief due such and such a time, and so on and so forth. I had no reason to expect anything changed. And he refers to the first time when this was supposedly confused and so on. It wasn't total confusion. There was a whole lot more, as I mentioned a little while ago, background than just mere confusion as to which judge and so on and so forth. I answered everything that I got at that time. And as I mentioned, right after I got his notice to the court to set a briefing schedule, which she did, but I didn't know about, but I had checked the docket a couple of times to see if something was going to come up on that. And it didn't. So then I figured, all right, I just gotta wait. Might be a month, might be a few weeks, I don't know. It took 2 months between the decision from this court in March of 13 to Tammy O'Brien's thing, Judge O'Brien's thing, tossing it back to Judge Rowland's. I think there's more than enough, as I mentioned about rule of court in one of my addendum pages for my brief towards the end, and about the stare decisis, because he mentioned case law in there too. There's a whole lot of stuff that somebody can fuzz up and fudge up to try to win a case. Essentially what the city is doing is trying to throw enough mud out there, and I'm going to get hung with it somehow or other if somebody upholds it. This is just one last thing that I had a traffic case that I had to go to the 9th District Appeals Court, but this was in Medina. This was about 3 years ago. And those people there did everything they possibly could to undermine that case, including Judge Chase. But I ended up winning it. I don't know how, but I did. But it was really a Pyrrhic victory. But it was what was right. And there's stuff wrong with what the city's going on with here. He's talking about, and if you read the transcript that came from the original Housing Board hearing, there's a lot more in there than what he just kind of went over in a couple of minutes. There's a lot of little minor things that they were just picking at, and as I mentioned in that the person that complained about it, it was part of a lot more of a vicious background. And there was deals going on between this one lady in Cincinnati and Mr. Groger with the city. They were trying to come out and pick anything they could to throw at me about that house. The only main thing about it was the roof. And then one of the people on the housing board in that transcript mentions about, you got the nicest house on the block. This is only a whole bunch of $20 problems. Well, no, I don't know that you could fix a roof for $20.
And Mr. Lavery, you've reached the end of your allotted time for argument today.
Thank you.
Thank you both for your presentations this morning. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on our website and the Ohio Supreme Court website. Thank you.